Resuming debate.
The honourable member for Richmond Hill.
Thank you, Madam Speaker. Madam Speaker, it's with great pleasure that I rise today to speak in support of the National Security Act 2017, Bill C-59. Madam Speaker, 2 years ago, our government came to Ottawa with the promise that we would address the numerous problematic elements of C-51, which was enacted by the previous government. Canadians agree that in attempting to safeguard the security of Canada, Bill C-51 failed to strike a balance between security and freedom. Today, I'm proud to be able to rise in this House and say that we have wholeheartedly delivered in this House our commitment to address those problem areas. Our government began its commitment to achieving this goal firstly by reaching out to Canadians in an unprecedented consultation process where all agreed that they need accountability, transparency, and effectiveness from their security agencies. Secondly, we passed Bill C-22 earlier this year, which creates the multi-party National Security and Intelligence Review Committee of Parliamentarians. It is tasked with reviewing national security and intelligence activities through unprecedented access with the goal of promoting government-wide accountability. On November 6, our Prime Minister followed through on this commitment by announcing the members of the committee. Today, we are debating the National Security Act 2017, Bill C-59, the last step in achieving our commitment to improving those problematic elements of C-51. This package consists of 3 acts, 5 sets of amendments, and a comprehensive review process. In creating the National Security and Intelligence Review Agency, the Office of Intelligence Commissioner, and the Communications Security Establishment, we have created the robust and effective national security establishment that Canadians asked for. In addition, we are amending the Canadian Security Intelligence Service Act, the Security of Canada Information Sharing Act, and the Secure Air Travel Act to strengthen the role of the Charter of Rights and Freedom, limit the collection of personal information, safeguard Canadian rights to peaceful assembly, and fix problems in the no-fly list. Finally, our commitment to Youth Criminal Justice Act will ensure that young persons will be provided all appropriate child protection, mental health, and other social measures when faced with a terrorism-related offense. Throughout my work on Mental Health Caucus, Madam Speaker, I know how important it is for all Canadians, especially those of marginalized groups, to have access to all available safeguard, services, and measures, specifically when navigating the criminal justice system. I'm therefore pleased to speak today specifically about these proposed amendments to Youth Criminal Justice Act, and that are included in Part 8 of the National Security Act 2017. Madam Speaker, my riding of Richmond Hill is an incredibly diverse and vibrant riding, where over half of my constituents are Canadian who come from an immigrant background, and of these, the majority are youth and young families under the age of 30. For this reason, I'm proud to say that through these sets of amendments, our government is taking action to ensure that all youth who are involved in the criminal justice system are afforded the enhanced protections provided by Canada Youth Criminal Justice Act, while also holding them accountable for their actions. The Youth Criminal Justice Act, or YCJI, is a federal law that governs Canada's youth aged 12 to 17 who committed criminal offences, including terrorism offences. The YCJA recognizes that the youth justice system must be separate from the adult system and based on the principle of diminished moral blameworthiness of the youth. It emphasizes rehabilitation and reintegration, just and proportionate response to offending, and enhanced procedural protection for youth. The Act also recognizes the importance of involving families, victims, and communities in the youth criminal justice system. The YCJA contains a number of significant legal safeguards to ensure that young people are treated fairly for that their rights are fully protected. For example, the identity protection ban and significant restrictions on access to youth records. Young people also have enhanced right to counsel, including state-provided counsel and the right to have parents or other guardians present throughout key stages of investigation and judicial processes. If a young person is charged, all proceedings take place in youth court. In addition, the YCGA establishes clear restriction on access to youth records, setting out who may access to youth records, the purpose of which youth records may be used, and the time periods during which access to records is permitted. Generally speaking, although the offenses set out in the criminal code apply to youth, the sentence do not. Instead, the YCGA sets out specific youth sentencing principles, options, and durations. There are a broad range of community-based youth sentencing options and clear restriction on the use of custodial sentences. Turning now to Bill C-51, it is important to recognize that there have been very few cases in Canada in which a youth person has been involved in youth criminal justice system due to terrorism offenses. In total, we've had 6 young people sentenced since 2002. 2 were fully guilty, 3 were put under peace bond, and 1 charges was dropped. Nonetheless, it is important to ensure that when these does occur, the young person is held to account, but also that they are afforded all of the enhanced protection under the YCGA. It is perhaps even more important in terrorism-related offenses that we do everything in our power to reform young offenders so that future harm is prevented. Part 8 of Bill C-59 will amend provision of YCGA to ensure that youth protection apply in relation to anti-terrorism and other recognizance order. It is also provides for access to youth records for the purpose of administrating the Canadian passport order, subject to the special privacy protection set into YCGA. The bill will also make important clarification with respect to recognizance order. Although the YCGA already provides youth justice order with the authority to impose these orders, several sections of YCGA will be amended to state more clearly that youth justice court have exclusive jurisdiction to impose recognizance on youth. This will eliminate any uncertainty about the applicability of certain rights of protection, including the youth right to counsel. In addition, there is currently no access period identified for records relating to reconnaissance, so the YCGA will be amended to provide the access period for these records will be 6 months after the order expires. With respect to Canadian passport order, Bill C-59 will amend the YCGA to specifically permit access to youth records for the purpose of administrating Canada's passport program. The Canadian passport order contemplates that passport can be denied or revoked as a result of certain criminal acts or in retaliation to national security concerns. For example, Section 10.1 of the Canadian passport order stipulates that Minister of Public Safety may decide to deny or revoke a passport if there are reasonable grounds, including that revocation is necessary to prevent the commission of terrorism offense or for national security of Canada or foreign country or state. The current YCGA provision governing access to youth records do not speak to access for passport matters. As noted, Bill C-51 will allow access in appropriate circumstances, but it is important to note that the sharing of youth information on this provision will still be subject to the special privacy protection of the YCGA. Madam Speaker, Canadians can be assured that our government is addressing the national security threat while continuing to protect democratic values, right of freedom for all Canadians. Those two goals must be pursued with equal dedication. Madam Speaker, I encourage all my colleagues to vote in support of this bill. Thank you very much.
Questions and comments? The honourable member for Barrie Innisfil.
Thank you, Madam Speaker. 2 simple questions for the member. First of all, sending it to committee, Before second reading, I'm just wondering what the honourable member hopes to see by doing that. And second question is, will the government be open to changes from the opposition side that are reasonable, that are practical, that will enhance the measures in this bill? Thank you, Madam Speaker.
The honourable member for Richmond Hill.
Well, I thank the honourable member across, and I would like to say that our government is committed through the committee to a process of taking everybody's input and taking all the members' input and implement the change and assess the changes and implement those as amendment if and when required. Thank you.
Questions and comments? Honourable député de Drummond.
The honourable member for Drummond. Thank you, Madam Chair. I would like to raise this boondoggle for Canadians that are listening to us, which is that we're not going to go directly to second reading. We're going to send a bill from this government directly to committee because it's too terrible. How is it this government is presenting such a terrible bill? Withdraw it and present a better bill to us. It doesn't make any sense. In this bill, I hope that the member will agree with me when I say that we absolutely have to remove all the directives on torture. We can't say that we don't accept information obtained under torture in Canada, but we might use information that could have been obtained under torture in another country. We can't wash our hands like that. We need to have strong principles against torture here in Canada and throughout the entire world. We can't accept that. Does my colleague agree with me? That's what I am asking. Thank you.
Hill.
I thank the honourable member across, and I'd like to say that, as I said in my speech, I'm focusing my comments on the amendments to the Youth Criminal Justice Act and the recognizance with conditions. And to that effect, our goal is to bring and strike the balance between the safety and liberty of those who are caught in the criminal justice system, especially those youths. Thank you.
Questions and comments? The honourable member for Aurora, Oak Ridges, Richmond Hill.
Thank you, Madam Speaker. And I would like to express that the honourable colleague's riding is right beside Aurora, Oak Ridges, Richmond Hill, and I would like to thank my colleague for the incredible work that he is doing with youth, and particularly in light of this Youth Criminal Justice Act. I wonder if he could give us some perspective on the balance between safeguarding society and giving our youth a just and proportionate response for their actions that have been reflected in this revised act. And in his opinion, what would be the three key elements that differentiate and improve upon this act that will make the biggest difference? Thank you, Madam Speaker.
Member for Richmond Hill.
Thank you, Madam Speaker, and I thank my colleague and my neighbor. Great question. So I'd like to start by highlighting some of the changes that's being proposed. Part 8 of Bill C-59 would amend certain provisions of the YCGA to ensure that youth protection apply in relation to recognizance order, including recognizance with conditions and peace-bound proceeding. So number one, we are bringing protection and making sure that that protection is recognized when it's needed. Second is that these amendments clarify that the Youth Justice Court have exclusive jurisdiction to impose these orders on youths and claim to eliminate any uncertainty about the applicability of certain provision to a youth for whom a recognizes order is being sought. Number three, in addition to these, and currently there is no access period, and what this amendment, this bill is proposing, the amendment to the YCGA, is to make sure that we have 6 months after the expiry date of the order limits the time that the youth records could be ordered. I notice that I'm running out of time, so I thank the honourable member and Madam Speaker for allowing me to respond. Thank you.
Resuming debate, reprise de débat, l'honorable député.